Hello.
Hi.
Good afternoon,
Hi. I'm Bill Wolf.
Misty Gutierrez. Good afternoon,
Hi. I'm Bill Wolf.
Misty Gutierrez. Good afternoon.
Wow, mine's echoing like crazy.
Maybe if y'all can try to get out and back in. I don't know what is going on.
Do you hear that? Like that echo?
I did. Okay, now I don't hear it.
Now I don't hear it either. Okay, so whatever.
Good afternoon, Council.
Good afternoon, Your Honor.
Is this everybody on Mondera Condominiums Association versus Stillwater Abbott Development?
I believe so.
Well, then, Ms. Rouse, let's call DC 20-07653 Mondera Condominiums Association versus Stillwater Abbott Development LLC and others. Before I ask for introductions, this proceeding is being conducted pursuant to the open courts provisions of the state of Texas, even though it is being conducted remotely. Now, for what it's worth, the doors to the court are, the courthouse and the courtroom are open. There are no members of the public present, but in addition, we are broadcasting this on the court's YouTube channel. And that is how we comply with the open courts provision, even if we're not in the courtroom. If you have an interest, all the courts in the state that are broadcasting their proceedings live on YouTube have a link at the Office of Court Administration, and it is constantly refreshing. And if you went there right now, for example, you would see that the 95th District Court is broadcasting live, and you can click on any court and see that court in action live off those links. That leads to certain complications because it is, absent an order of this court, it is prohibited to record any proceeding in this court, including this proceeding. Neither the participants nor the public are authorized to copy, record, or otherwise save images from the proceedings of this case. Again, absent further order of this court. There is one record and one record only that comes out of this proceeding, and that is the record maintained by the official court reporter of the 95th District Court, Ms. Rouse, who is here and reporting this. Any questions about that?
No, Your Honor.
No.
Very good. Then allow me to ask for introductions, starting with counsel for plaintiff.
Misty Gutierrez, for plaintiff Mondera Condominiums Association, Inc., and I have my colleague James Ewing with me as well.
Your Honor,
Welcome you both to the 95th District Court. Mr. Wolf, that leaves you.
Your Honor, Bill Wolf. I represent and have answered for all of the defendants, but today's motion only relates to 2.
Very good. Do you care to say
Sure.
specifically who?
Yeah, Robert Elliott and Stillwater Capital Investments.
Very good. Again, welcome to the 95th District Court, Mr. Wolf.
Appreciate it.
I have an observation before we even begin. Ms. Gutierrez, your motion was filed in violation of the local rules of the Civil District Courts of Dallas County. It has far too many pages. And I'm going to choose not to take action, but I ask you to be cautious about the page limitations that were set out by the 12 other civil district courts back in April and have been readily posted everywhere. And then they were adopted by this court the day I got sworn in as judge of the 95th, which was July 30. I also have a question, if I may, before you begin. You reference a certificate of service and you reference answers to certain discovery responses that were given, that were made by the defendants. Where are those?
Your Honor, I just emailed them to you because I found it amazing to violate the page limit but not put in my responses. So I emailed them.
All right, Mr. Wolf. Fair enough. I was actually addressing Ms. Gutierrez.
Sorry. Okay.
Ms. Gutierrez, where are they?
The discovery responses and the certificates, I thought they were attached to this very lengthy motion, but perhaps they're not, and we can amend and submit that. We have the return of service attached as Exhibit A for Robert Elliott.
That's the return of service of the citation. This is a motion to compel discovery responses, and you gave me everything under the sun. You gave me, Mr. Wolf. All right. I mean, I'm not, if half of what she says in here is even remotely true, I am not pleased with your client either, but that's,
Okay.
I'm staring at a motion to compel that threw everything in under the sun except for the discovery responses that you're complaining about. You sent me emails, you gave me a long recitation of the case, and it's a motion to compel discovery responses, and you don't tell me what the discovery responses are.
Your Honor, that was an oversight on our part. I apologize, did not realize those were not attached. If you'd like me to share my screen, I can show those to you right now.
I'm really not interested at this point. And we're going to proceed a little bit further. Mr. Wolf.
Yes, Your Honor.
Were the discovery responses emailed on, I believe it was August 6th?
No, Your Honor.
They were not?
They were not.
Does the certificate of service say they were?
No, they specifically say that they were mailed, and they were mailed. The certificate of service is exactly what it says. It was done, was done.
All right.
They're postmarked on the 7th. Yeah, okay.
All right. Ms. Gutierrez, your proof on the late service that you're claiming is that there's a postmark. Do you understand the difference between the postmark, the postbox rule and the date that the Postal Service actually postmarks something?
Yes, Your Honor, I do.
All right. Do you recognize that it is possible that a document, in fact, often likely if it's dropped in the mail at or near 5 o'clock, that it can be dropped in the post box and not bear a postmark until the next day?
I do.
All right. Are you really going to hold, even if they were a day late, are you really going to be a stickler on holding the other side to a day late when we're talking about now 51 days after service of citation?
Your Honor, that was a technical argument that was really in response to the technical objections we received. I think that we have, frankly, firmer footing on the other objections, which I don't think were made in good faith, and that we have no attempt to comply with our discovery request whatsoever.
All right, I'm going to address this to you both. Court should not be having to play referee on discovery, except on things that really are of substance. Mr. Wolf, your client has an obligation to make discovery of all matters that are asked about, that are relevant to any claim or defense, or that may lead to the discovery of admissible evidence on any claim or defense. So that's almost verbatim. I added a couple words at the end, almost verbatim out of the rules of civil procedure. If you are not doing so, and it can be demonstrated that your client is not doing so, this court will bring the hammer down. Ms. Gutierrez, I read your motion. Obviously, I've read it in detail. I understand your frustration. What happened before this litigation, however, is not relevant to a discovery dispute. You have an obligation to sit down with counsel and endeavor to come up with a solution to whatever discovery is outstanding. And then come to court with a motion that says, interrogatory number 3, the objection is wrong, or the objection is not supported by law, would be not just global. Their objections are no good. A global discovery dispute doesn't get us anywhere.
Your Honor, if I may, they made global objections. They made 2 objections globally to every single response. And again, I apologize. I had no idea that those responses were not attached to my motion. That was a mistake on my part, but they were global objections. They were the same 2 objections on every single response. We didn't get a single answer. We didn't get a single document. We didn't even get responses to disclosures for which objections aren't even allowed. So the reason for the global motion is because we got global objections. I could have gone interrogatory 1, interrogatory 2, interrogatory 3, but it would have been repetitive, the same thing over and over.
I'm understanding, and I understood that from your motion, and I was going to go back to Mr. Wolf now. Mr. Wolf, did your client really object to request for disclosure?
Your Honor, we did. And can I explain?
And if you can tell me how you're allowed to object to point me to a rule that says you can object to a request for disclosure, I'm going to cite you to
the Dallas Court of Appeals, you can't do discovery in a petition. All this discovery is in paragraph 29 of the petition, and all of the discovery that's interrogatories and requests for production are attached as Exhibit A to the petition. I'm reading from Witham versus Underwood, which is a 1997 Dallas Court of Appeals case by Justice Thomas and Whittington and Bridges. And it says the dispositive issue in this appeal is whether a plaintiff who attaches discovery requests as an exhibit to his petition has properly served those requests when he serves the petition. We conclude discovery requests attached as an exhibit to a petition are not effective. Goes on to say that there's some issue about because it was done through alternative service, but then the Court of Appeals again goes on to say, assuming the envelope contained in the original petition and attached exhibits, Texas Rule 59, Texas Rule Civil Precision 59 allows that written instruments which constitute in whole or in part the claim sued upon can be attached to pleadings, TRCP 59. The rule strictly prohibits pleadings, the rule strictly prohibits attaching other instruments of writing. That's Rule 59. Discovery requests do not constitute in whole or in part the claim sued upon. Therefore, according to strict wording of the Rule 59, Underwood improperly attached the request and exhibit to the petition. Because the request could not be properly attached to the petition, they necessarily could not be properly served by serving the petition. So I learned this by having someone pull this out and say, it's rule of law and here's the law. And so, and it's not been changed. It's actually been cited, and it's the idea that Rule 59 does not allow discovery. And what we get is more and more of this, everything's attached and there's 60 things of, the petition comes and it comes like a tidal wave. And I have tried to get insurance counsel involved and not spend my client's money. So this was a way to say it was all infirm. And I based that on the Court of Appeals. So yes, I did object to every one because it's attached.
In my response to that, and I haven't read that case, is that our rules specifically contemplate an extended deadline or discovery that is served before a party has to answer. And quite frankly, we see every day discovery served with petitions.
May I respond?
Yes.
Served with, where the return of service says I serve A and B and C types of discovery, is not the same as attaching to the petition that violates Rule 59. Those are two different things. And maybe it's not something that many people recognize or what the law is, but it's been the law since, unfortunately, I've been practicing long enough that I was like a 15-year lawyer when it happened, but it's from the last century. And it's consistently been applied when I've dealt with people that just apply the law. And it's not a big deal. It's the case is a 20 case. You issue this discovery correctly, and we follow the law that exists.
We're going to go on recess for just 2 minutes.
Thank you.
Thank you.
Counsel, whenever you're available.
Ready, Your Honor.
Ready, Your Honor.
I think the distinction, we're back on the record, Ms. Rouse. I think the distinction Mr. Wolf is making, and I think has a point in an elevation of form, is that you can't make it part of your petition. You can serve it with the citation. Is that yeah, I believe he is right on that.
That's exactly
the discovery is not a pleading. It can be served with the citation. But having said that, again, this is something that should have happened with you two picking up the phone and talking to each other, to be real blunt. I mean, to be real blunt. I'm going to let you sort out your discovery. And if Ms. Gutierrez, if that means you have to reserve them using Rule 21A, reserve them using Rule 21A. If you can convince Mr. Wolf to say they're deemed received as of a date certain, then because he's already got them, it seems silly to start killing paper or chopping down trees, not killing paper, chopping down trees to adding to the paper, then do it that way. Serve through the e-filing manager. That's how I was in practice for 35 years before I took the bench last month. We started doing everything by the e-filing manager. I mean, that way you always have a record of exactly what's served. And you can even tell opposing counsel, you didn't get it because it was served on you and you didn't open the email. I mean, that all is right there on the e-filing manager.
Your Honor, may I briefly respond to just tell you I really trying to get insurance is what I'm really trying to do and get me out of it.
Fair enough. I understand.
I'm not someone
that too.
Yeah. And I'm not down here with people. I don't answer stuff. I mean, that's not me.
But you should also pick up the phone and call her and say, I don't want to answer this on my client's dime when I'm trying to get the insurance carriers involved. And you should be able to pick up the phone and call her and say, can we hold off until I get a response from ABC Insurance Company? That involves the two of you talking to each other.
Fair enough.
And Your Honor, a part of the issue here is we're trying to get them to tell us who the subcontractors were on this project. The subcontractors bring additional pools of insurance. They allow them to spread the liability around, and we've been trying informally for months. I understand you don't think that's relevant, but we've had a number of conversations about this. And in fact, when they were in default, I called and said, hey, your guys in default. Before I go through with this, I want to let you know. So we have not failed to extend professional courtesies. We have tried every possible means of getting insurance information and subcontractor information so that more than just Mr. Wolf's clients are on the hook here. And that is why we need this information, and we need it sooner rather than later, before limitations is passed and we can no longer get to any of those other parties.
Mr. Wolf?
Another 30 days or 60 days is going to continue to cause issues for us on bringing those parties in.
Mr. Wolf, is there a reason your client is not providing that information?
Your Honor, my goal was to provide all this through counsel that they get billed like crazy. And I really am very sensitive to the idea that $2,500 with a pandemic and everything shut down is important. I've practiced 38 years and I try to, if I can, I'm a fiduciary, I shift anything. So that was the goal. That was the reason, that was the approach. Right. Not to do anything other than to benefit the client.
Motion to compel is denied at this time without prejudice to it being re-brought on the same discovery. If you understand what I'm getting at, you two need to sit down and have a professional discussion about these sorts of details. It should be very easy for you to, Mr. Wolf, to tell Ms. Gutierrez who the subcontractors are if they're relevant in this action. And I didn't say pre-suit discussion is irrelevant. It's irrelevant to your motion to compel. That's what I was saying. If need be, the court is ready to issue such orders to compel you to act professionally towards each other. I do not anticipate the need to do so.
Thank you, Your Honor.
But it does require that the two of you sit down and have a professional conversation about these things.
Very good.
Is there any ambiguity in that?
No, Your Honor, not to me.
Ms. Gutierrez?
No.
All right. Then you're excused for today. Work these sorts of details out. I'm just gonna, let me say this. I took the bench a month ago, and one of the first things I did was issue a new set of policies and procedures. And I talked about, paragraph 2 of it, talked about how difficult the practice of law is. And it is. And my job as judge is not to make your life more difficult. Your job, you owe an obligation both to each other and to the court, but really first and foremost to each other, to act professionally with each other at all times. And if you do, you should be able to agree on almost every matter of procedure. Now, there are some sticking matters of privilege. Substance, fight about all day long. That's what we're here about. We're here about to resolve substantive fights. Procedural fights, you should be able to hash out almost everything except for those things really on the margin. Fair enough?
Thank you, Your Honor.
Thank you. All right. Y'all are excused today.
Thank you.
Stupid fight. All right, we've got 3 people waiting to enter. I'm all for it.
All righty.
Actually, I'm going to go off screen here for just a second.
Okay.
Here we go.
Hey, Brett, how are you?
Good, Robert. How you doing?
Doing well.
Good. Looks like we got Judge and Deanna here frozen.
Oh, I'm here. I just don't have to be on camera.
No, I got you. No worries. I figured that was the case. I hadn't figured out how to do that yet.
Stop video.
Oh, stop. Well, but I mean, put the picture up there so it doesn't just show a blank screen.
I think it's because of my Google account, maybe. I'm not sure.
Ah, okay.
Got to go
Gotcha.
to your settings.
I'm still getting there, Your Honor. How are you?
I'm well, thank you. Welcome
Great.
to the 95th District Court.
Thank you.
Thank you, Your Honor.
You are most welcome. Now, I got to tell you,
Happy birthday.
this violates both the emergency orders and the local rules and the policies and procedures of this court. Now,
We have a motion that we were going to file, Your Honor, but Mr. Whitty was kind enough to indulge us and try to work something out for you, and hopefully you'll be fine with it.
I just got done with the judges meeting before that last hearing, and it was my first meeting of all the civil district judges since I was sworn in, and I held that up. They were some of them were complaining about forms of orders that are being submitted. And I said, well, how about this? And I held this up, and I don't mind telling you, here's what one of my fellow members of the bench did. Held up this.
Throw it away. Yeah.
I'm not going to, in part because I'm going to anticipate, rightly or wrongly, that what was submitted are the exhibits that are intended to be offered at the hearing.
That's right.
That's the reason there are skipped numbers. For example, you at one point had a 56, and there's no longer a 56. You went to 57 because 57 is going to be offered.
These are all the exhibits that we intend to offer. That's right, Your Honor, at the PI hearing. That's exactly
all
right.
Well,
and that's what it is. It's we just kept the numbering from the depositions. Of course, the depositions were sequential. We did not use them on the briefing. The brief is fantastic, Your Honor. I'll brag on Mrs. Baker, who's on the Zoom with us. She did all the work. If you love it, it's all hers. If you don't love it, it's all mine.
All right. I'm not going to complain, in part because otherwise you'd have to email all of those to Ms. Rouse in order to make a record. I wish you'd put exhibit stickers on them, but I can live with Bates exhibit stickers also.
We can put some stickers on them and have it sent back.
It's over. It's a pain. It's a pain to go back. I can live with that. That creates a good enough record if it becomes necessary. So
yes. And we put Mr. Whitty's paper at the back. He didn't have any additional exhibits, so we put it at the back.
I saw it.
Okay. And then we have a reply that's due by close of business.
Your Honor.
Yes. Mr. Whitty.
Well, I was going to mention, we do have exhibits, but one of the reasons we wanted to have this call with the court was to find out how the court preferred us to present the exhibits to the court.
Well, I'm inclined to go. Are we going to try this by Zoom?
Yes.
Yes, sir.
You have two options. And I actually like this one better, even though it's probably technically violates the emergency orders. Because that way I've got them. I can hold them for I will consider this not a courtesy copy or whatever. I'm going to consider that the exhibit binder, at least everything past the brief. So I guess it makes sense if you deliver to me a copy of the same. Are they also going to be? I was a big believer when I was, and understand I practiced law for 35 years before I took the bench. And I loved the idea in large cases of numbering exhibits in deposition, not deposition exhibit Jones 1. Instead, this one is just the next number that, and so is Mr. Woody, would any exhibits you have to be offered fit within the same numbering scheme?
Yes, they do fit within the same scheme. And if it would please the court, we would not duplicate exhibits that Mr. Govett has already provided the court.
I'm not gonna, look, there's gonna be no preference or no presumption given by any part. Oh, well, that was a plaintiff's exhibit, not a defendant's exhibit. I'm not gonna draw any presumption on that. So yeah, I'd much rather have one copy and have it be numbered.
Perfect.
Sequentially, that
Perfect.
makes sense.
Your Honor, one other thing we wanted to raise, we did object to the length and the fonts on the plaintiff's brief, but as Mr. Govett has referenced, if it would please the court, Culinaire has agreed that we would just be able to file a supplemental brief on Monday.
Is that what
25
today, is
pages
that
of
what today was about? Because I heard it was about briefing schedule.
That was part of it. As Your Honor may have noted, we did object to Culinare's brief due to the standing rule on page limitations and font size. But we have tried throughout this to work things out. And if it would please the court, that is what we have agreed to.
Okay, that's fine.
Okay.
Now, that's
And-
perfectly fine.
And Your
The,
Honor, it'll essentially be a surreply, Your Honor, because we had previously agreed that we're going to file a reply to their response by the end of the day tomorrow. So they'll get the last word and it's fine. And that's
all
fine.
right.
That's fine. And
So
I
what
think,
are we going to try?
well, so we have the, exactly what are we going to try? I believe it's just it. And that was part of the reason that we did what we did, Your Honor. Obviously, we apologize for not catching the standing order. It's just, I accept responsibility, but be that as it may. We were given 1 hour and there's a lot to cover. So and that's obviously 30 minutes aside. So we were intending just to argue the points on Tuesday, say 20 minutes and then reserve 10 minutes for rebuttal. And then Mr. Whitty does his 30 minutes and then we take the 10 minutes at the end. And then of course, as you indicated, we would ask that all the exhibits that we have there in the binder be made a part of the record for the preliminary injunction hearing. And
So-
then that's essentially it.
So we're not going to have to call witnesses to prove up all these exhibits,
No,
whether they're yours or Mr. Whitty's.
no,
All right.
no.
Because I was looking at the schedule and someone gave you 2 hours and I said, to admit all of those is going to take 2 hours.
Well, we got 2 hours. I didn't realize we had 2 hours. Okay, well, thank you.
The reality is you've got the afternoon. There's no one else set Monday afternoon, or this is Tuesday afternoon, isn't it?
Yes.
Nobody else set Tuesday afternoon.
Okay.
Um,
And do you have it at 2 o'clock? Because that's what we have it. I just want to make sure.
Actually, got it at 2 o'clock.
Okay. And while we're all here, I assume it was originally set for Zoom. That is fine. I don't know if you would rather us come down. Probably not. But
Honestly, if you want to know the honest truth,
Probably.
I'd rather you be in the courtroom. But there are certain complications to that. Now, if it's just the three of you, it's really not that big a deal, except for the fact that then Ms. Rouse would have to come down here. And we've got other things Tuesday that are definitely going to be remote. And so she's going to be doing those from home. I mean, it's easier probably to do it by Zoom.
okay, we don't wish to rock the boat. Not at all.
Correct.
Not at all.
Okay.
And that's what we had planned on. You made the statement earlier, so, okay. I think that's it.
I didn't know that there were not going to be any witnesses, which,
Well, that's why we had 10 some odd depositions and we were rushing to get all those. And so that's why the papers are as they are. And we just figured it was a whole lot easier to take all the depositions, condense it down, and then package it the way it was packaged and present it to the court and have some argument and get on down the road.
are
Your Honor, as far as our exhibit,
what's that? Excuse me, Mr.
I was just going to say, as far as our exhibits, do you want us just to send them to Ms. Rouse, or do you want us to file them in the manner that they will?
Deliver them in a binder like this was done.
Yes, Your Honor. We'll do.
In fact, are you downtown? Is your office downtown?
Currently, yes, we have an office downtown. I'm currently up in our Frisco office.
All right. mean, it would be easiest and best if you'd hand delivered them to the clerk and they'd bring me a package like this. And I was told, and I thought it was my bench book when it arrived, and started opening the box, and it was like, yeah, which I've got electronically, but I've been waiting on the physical bench book. And I was like, oh no, this is definitely not the bench book. It would be easiest if you delivered them to me, and that way I've got the full set of exhibits. I can deliver them
Yes,
to
Your
Ms.
Honor.
Rouse for the record.
Yes, Your Honor, will do.
And
Because
when we,
she's not, yeah, she'd
Sorry.
rather not keep them at her house anyways. So, what was that, Ms. Rouse?
I just laughed.
Oh, all right.
and when we file our paper tomorrow, Your Honor, if whatever it is, we'll file it and package it similarly and just have it hand delivered as well
All
Monday
right.
morning. It'll
Very
probably
nice.
just be a GBC binder with the, you know, the little paper in it and the rest. But that's what we wanted to visit with you about today. Really appreciate you making the time. Thank you.
It's my pleasure. Now I'm going to say this. I come to hearings exceptionally well prepared, or at least I try to. I asked the last people. I began the hearing by pointing out the deficiencies in her motion, specifically what she had not in 88 pages, what she had failed to attach, for example. I do not, and I have a working knowledge of this case already, and I'll have more of a working knowledge by the time we go, but I am not planning on reading in advance of argument 1,250 pages of exhibits. Please understand that,
No,
or
totally
all
understand.
those depositions. I'm
Absolutely.
going to trust that you will spend the time to point to the pages of the depositions that are attached and the exhibits, specifically what I'm to be focused on to render a judgment. Can I count on that?
Oh, yes.
Yes, Your Honor.
Which does lead to this. What are we going to do on the depositions?
They're in there as well, Your Honor.
I know, but they're not a record unless they're admitted as testimonial evidence, unless you all decide to accept them as.
I believe we would ask that they likewise be admitted, at least the portions that are cited. We included the entire depositions to try to make it easy for the court and for Mr. Whitty. There were certain parts that were attorney's eyes only and confidential. We took that out. We redacted that out. Is that good with you, Robert?
May I suggest you two come to an understanding of how to create that record within the time constraints that we have, rather than reading the individual pages in the record. And there are ways to do it.
Yes, Your Honor.
We can do that.
All right.
Sure. That's fine. That's fine. Okay. And then I just had a question. I see the YouTube in the upper left. So if we go to YouTube and
you did not get, because we just jumped in here and rather informally, you didn't get my opening recitation. This matter is conducted, even though it's conducted remotely, it is conducted pursuant to the open courts provisions of the Texas Constitution. To comply with the open courts provisions, number one, the courtroom doors happen to be open. There are no members of the public present, but they are welcome. But secondly, we broadcast this on the court's YouTube channel. If you have an interest, the Office of Court Administration, it maintains a constantly refreshing list of any court that in the state of Texas, any state court that is live on YouTube at any given moment, with a link to that court's page. So right now, if you went to the OCA, you would see that the 95th is live, and you could click on that and you go straight to our YouTube page.
and we'll see this. We'll see this.
Yeah, you would see this, exactly. What I've noticed is, and I haven't spent a lot of time looking. I think it only shows the active speaker on the YouTube channel. I don't think you see the 4 or 5 block thing.
Interesting. Okay.
That creates certain problems. Recording of this proceeding or of our proceeding on Tuesday is expressly prohibited. Neither the participants nor the public are permitted to record a proceeding in a state district court absent specific permission from the court. So you are prohibited from trying to create a record out of what is being broadcast live on YouTube. There is one record only. Ms. Rouse maintains the official record of proceedings in this court, and any record has to come through her. That's the spiel I give at the beginning of every hearing.
Got it. I'll give it a try. Are you having hearings tomorrow?
Yes.
Okay.
I mean, yeah, yes. I'm having hearings every day. This court was backed up without a judge for, I mean,
Oh, I
other
know.
than
Long time.
very good visiting judges. I mean, outstanding judges, but they were visiting judges. Yeah, although today actually it was surprising you were able to do this. I had at one point 8 hearings today, and they cratered down to 2.
Oh, wow. And we're the second, I guess?
And that doesn't count the dismissal docket. Yeah, you're actually the third. But
Okay.
even the first one this morning ended up being an agreed dismissal. So the briefing convinced one party to give up. Yeah, I'm on. We're on from 9 tomorrow until about 11:30.
Okay, perfect. Appreciate that. It's all new to me.
Well,
I've only been practicing 30 years, so
it's
you know.
listen, it's new to all of us.
I mean, you know,
I mean,
still trying to figure it out.
one of my colleagues is still doing everything by phone, and it's like,
Yeah, that's hard.
that's so tough. At least I can see you.
Right.
Yeah, it is.
I mean,
exactly.
it would be much better to see you out here.
Oh, believe me, we wish. And so one question I had on the Monday hearing, and I'm sure Robert will have the same issue. If we want to use slides or show
You
something.
mean Tuesday, Brent?
Tuesday, I'm sorry, Tuesday, yes. We can do the screen share.
If you have demonstrative things, or you want to point out something specific that's in one of these, you absolutely can use screen share.
Okay. Okay, perfect.
And it is the way to go.
Right.
I mean, it's equivalent of
Holding, put it on the overhead.
broadcasting it on the,
Correct.
in fact, if I wish,
Oh, you can put it on there.
I have figured out how to put that on in every screen in this courtroom. The problem is it causes me to look over here rather than over here, from the standpoint of the camera view.
Right. Okay. Understood. Perfect. Okay. Then I think that's all we had. Robert, do you have anything
Yes.
else?
That's all from this side as well.
No.
Okay.
Do you have any questions of us further?
I don't think so. I'll look forward to your binders and exhibits and whatever else is coming.
Okay. Well,
Yeah.
we appreciate you
you,
making
Your
the
Honor.
time. Yes.
Thank you.
Thank
We do
you.
appreciate
All
it.
right.
Okay. Thank you. Bye-bye. Thank you, Deanna.
Bye-bye.
Bye-bye. Bye-bye.
Bye-bye.
Okay, Dina.